I appear for the straight respondents in this matter.
He is very apprehensive. That shows that he does not have a good point.
No, my senior is looking for these central GST authorities. They are the answering respondent, and they are not present here.
I just thought that he's very skeptical about it. So I just thought that he's not sure. Yes.
My lord, so pleased to grant expeditious hearing of this matter. But the lordship, the reason was this, that
any emergency situation.
They had fixed the hearing yesterday, and the writ petition was moved on Friday. So the hearing was yesterday. The learned judge was pleased to dismiss the writ petition, and therefore we served them and requested them not to proceed with the hearing. And the matter was mentioned before my lords, and my lords were pleased to have it.
What has happened yesterday?
We have only made a written request. We have no information. And that was not.
Where is the GST authority?
I'm
have you given them a time, because they wanted to pursue the remedy? So the writ petition has been dismissed, but they have come up. So during this vacation, are you going to take any drastic steps?
Not drastic, but I have to go ahead with my adjudication. My problem is under section 74. Yes.
Is there any time?
Yes, I have to.
In which you have to complete
5th of 2025.
What?
I have to complete 5th February 2025. I have to complete my adjudication, and I have to give the portal upload. It's like arbitration, and after 121 days, even court cannot condone my delay. So, Lordship, in that case, I have to proceed. If the Lordship looks into his matter.
Then you did not have to. I was just thinking whether it's the last day before the vacation. So that's why I was thinking anything, if it can be postponed to a reopening.
I think it can be done.
Should be there.
Lordship, then in that case, let me proceed in between time, because the proceedings is having a certain paraphernalities which has to be done. Let us proceed with that. If he gets a chance, if he succeed in his writ appeal, then Lordship, he can always add on. But today, I am calling him to make a representation. I will try to demonstrate from my show cause that what I am...
it is something very... the intelligence department has gathered certain information in a search operation.
Essentially,
you wanted that principle of natural justice to be followed, because those sensitive information should also be disclosed.
I do not want the sensitive part at all. And that's why the learned judges, in my humble submission, heard, because that was never my prayer, because I relied upon a judgment which says that redact the sensitive part. That is not to be disclosed to me.
That's true.
So, learned judges dismissed the writ petition only on the basis that as if I'm seeking the sensitive part. I'm not.
Then what do you sought?
There's an investigation which has happened, investigation report which is there. Now, the show cause notice speaks about the investigation, and I was requesting for a copy of that, because I had paid GST. I had paid on a turnover of 719 crores over a 5-year period.
Your junior was mentioning that they have raised a demand of 6,000 something crores.
Yes,
when your total turnover since last 5 years is
719. 719, and they have 6,000. So the entire I have to be very careful in how I deal with this matter. And if something is available to me, they've referred to in the notice. I would be humbly submitting.
What game you organize?
Because
your name says gaming.
I have an online platform, where different games are available. So individuals who want to play the games, they log into the platform. They pool in their own money, which the winner takes. I get a small percentage of whatever they pool in, which is the platform fee. So now on that platform fee, I pay taxes. Now they want to change the nature of the transaction itself and say that I have to.
Is it permissible in law? This kind of a platform, the game,
yes,
or
it is permissible.
So far as IPC is concerned, I'm not aware. But so far as my case is concerned, that if you are allowing someone a platform, how he is doing, kindly see.
No. He is doing that. He is providing an avenue to the gamers to
Yes.
come and play
between
in
themselves.
his space which he provides, the space which he provides, and the facilities which he provides.
And both of them are
We have
putting money.
technology, everything. Now he says that since you are using my space, you are using my area or a platform, whatever, then you'll have to pay certain fees.
No,
This is
not
what
only
I
that.
understand.
He has a wallet with him also.
Now the question is, wallet is as a custodian. If somebody keeps the money as a custodian, say for an example, a transaction, say the sale of the immovable property attracts a GST. Let us hypothetically understand. An agreement for sale is entered into, and then a substantial amount or a sum of the amount is taken. Sale is not complete as of now. This amount remained with the vendor, the owner, to be adjusted and appropriated the moment the sale deed is finally confirmed and the rest of the consideration money is there. Till the time that sale deed is not complete or the remaining consideration is not paid, whether this amount which is received as a custodian, which can be refunded because in the event the sale fails, will be chargeable under the GST, or it will remain postponed. I'm just thinking.
Yes, absolutely.
Postponed, and it will attract GST the moment the sale is complete. What is your reaction?
But it will not attract, but my case, if I may humbly put it,
Because the wallet.
No, Lordship, but I'm
really a custodian of the
money. No, if it is a.
Because that money would be utilized by those gamers
not by
the
me.
moment they log into the platform and then use that money.
True.
So he is not really earning
anything out of
that because it is to be used by them as a wallet.
No.
That's why I gave you an example.
Now, if I take that example as a clue and a reply, if it is refundable in nature, all right. But when the money, like now, just come to the bank side. Money kept in bank. Moment I enter a service for that, then the service tax comes into play.
True.
GST. Now here,
when the service will come,
when he will deal with the money.
Yes,
he will deal with the money, not barely deposit and return back. Lordship, kindly come to page 170. Kindly, exactly, Lordship is on that point. 170. 117. Exactly by question and answer during investigation. This is a show cause notice. In the show cause notice, exactly I have given that picture. That how you are dealing with the money and how you are evading. Lordship, kindly see. Two persons are gaming.
Question number?
119. 19.
Yes.
Lordship, two participants.
Yes, it would appear that you had a company charged and paid census on the face value of the event.
Kindly see. Both of them are giving 100. He is holding 100. GST he is giving 0. Then he is taking his 1. And then he...
Okay, you are putting a question as if that his business policy is absolutely wrong. Because he is charging more than in relation to...
No, Lordship, I am coming to that. No, I am coming to that. This is the pattern he is following. So he is then taking that 100 rupee and giving back to someone else. Then he is dealing with the money. He is substituting it to the winner. Moment he is dealing with that money.
What I'm saying, there is the distinction has to be done.
Now, Lordship, kindly come to the next one.
Suppose a custodian of a money.
Custodian
utilize that money. He has to return it to
No.
the main owner of the money.
No, Lordship, that's the...
The owner utilizes the money. Then and then.
No, owner cannot.
Liability.
So, Lordship, one is losing, one is winning. Moment one is losing,
They are always the winner.
No.
Even a loser have to pay a certain amount.
he...
Winner has to
Lordship, this is a wagering...
for use
No,
of the
no,
platform.
this is a wagering contract. He is keeping the money with him in a wagering contract and he is dealing with the money because he promised to the other man, then I will give you this if you win in the wager.
That's all in all.
No.
Mutual fund is how I
What? I could not get it.
In a wager, yes, I'm getting. He is the platform, he is not only playing.
He's not playing.
No, he is providing the playing. Then he takes the money in his hand.
Yes.
Now it is his, no, not as a security.
Suppose a security.
No, it's a positive promise to him, by him.
Because the reason is that he will not leave the platform because that money is lying with him. So he has to come and log into that platform. That's a business tactic.
So, no. Policy. Then he is holding the money for whom?
He's holding the money on behalf. For whom? No. On behalf.
No. He cannot. He can only hold the money if my money.
Suppose the nominee, if it is given. In many banking transactions, in many other the insurance, there are many other.
Lordship, nominee in a wagering contract and in a.
Merely a custodian. Suppose if he goes, he collects the money. Does he become entitled?
Anyway, that is a matter of adjudication, Lordship. I will come back to that.
Oh.
Now, what today we are arguing before.
I see judgment against you of the Supreme Court.
I'm not aware of Lordship. Then Lordship kindly come to.
What is the role of the nominee? He's merely.
No, that I know. He is a custodian. He has to distribute amongst all legal heirs. Lordship, that is there. He has to distribute among all legal heirs.
It's a charge for the moment we give the play winning and lose then
now Lordship
a certain percentage from it, and that will attract the GST.
Lordship, kindly see why there.
There's a slate face because he says, I think he is of the view that the court is going in the wrong direction. Let him go and keep him silent.
No, but I'll explain.
No, that is what I'm not confused. Confused.
It's not a confusion.
No, sir, my confusion. Sir, 31A says, how the rule 31 says, value of the supply in case of a lottery, betting, gambling and horse racing. I have a particular rule to that extent.
100%.
So the total amount has to be taken. What he is 100 and 100. The entire money.
I do not know what is the modalities there. Suppose as a
Lordship, today let's.
A person, he says that I want to play the game. I'm a big gamer.
That is.
But I am having now 10,000 rupees in my bank account. I transferred or converted that 10,000 rupees into their wallet which they have created.
Right. Lordship is.
So it is really I would say the transfer of a money or passing of a money from one source to another, from one place to another place. That is true. Suppose I do not know what is the software. That person later on realized that no, I do not want to play in this platform.
He cannot go out. His money he is already deposited.
His money to be returned.
Yes.
They are bound to return.
Yes.
Keep it. If they keep it, then they will be exposed under a different panel.
Lordship.
So in that event, if that being the position,
yes,
the wallet would be only that he is holding that money, but not utilizing it for any benefit.
Right.
The moment the owner of the money, he utilizes the money.
Understood, man.
On their platform, then the amount of utilization would attract the I would say the tax liability, not the mere keeping a
Lordship.
The wallet will not attract.
True. I am agreeing with you.
Where is the problem?
Lordship. Now, Lordship has discussed the entire thing with me, whether the GST will attract or not. Did Lordship enter into any question whether my investigation report was what? No, Lordship did not ask me. This is the job of the adjudicating authority. We are asking him, these are the statement I collected. This is the tax to be paid. This is your business model. This is my law. So according to this will be the demand. No, this is what fallen from your Lordship. Correct, incorrect, that's a different issue. He has to convince my adjudicating authority. So that's the reason why I tell right to convince your Lordship that exactly the discussion I said, no, it is applicable. Lordship said, no. Lordship has given me example. This discussion is going to happen before an adjudicating authority. And for that purpose, Lordship, neither we need. Yes.
What is the role of a court? What is the role of the court? If the court finds that the adjudicating authority under the statute is acting beyond the powers which is conferred,
Lordship,
blatantly in contravention to the law which is there in place,
Lordship can quash my show cause notice. That's not the challenge they have thrown me.
no difficulty. In order to ascertain that whether you are within your powers, you say that they were keeping a money in your wallets. That's why
That's right. That is exactly the adjudicating authority will discuss.
Let us discuss whether this wallet attracts. Yeah, wallet attracts.
So if Lordship is today if we are talking today before your Lordship on basis of the validity of the show cause notice, that is not under challenge.
Now suppose I am talking about the income tax perspective. I have earned, I have shown, I have paid the tax. Now it is me, either I can keep that amount after payment of the tax in bank or in hand. I keep it in hand, which will not attract any other income. If I keep it in bank, then the bank will give me an interest and the interest will again be treated as an income.
So
suppose in hand, I keep it. It does not. Can you say why you are keeping in hand?
no, Lordship, today,
I fully tax paid money.
so Lordship, whether the
That will come later on. I'm talking about if there is no restriction of keeping.
no, not keeping in the, of course, there is for a purpose of gambling, that's a different. So Lordship, today the show cause notice is not under challenge.
Making any income from that wallet. It's intact. They can't utilize it.
I don't know.
Have you got
Investigation and adjudication will get it.
by making any investments anywhere?
Lordship, that's what I said. Lordship, what I will submit now before your Lordship. If that is the purpose of the adjudication, what we tried to do superficially here, that adjudicating authority will go into it. So for adjudicating authority, what we need is, so Lordship,
So this adjudication has to be done within a time frame.
There is a time frame, but not if the court is pleased to. No, I must indicate not. There's a originally writ petition was filed, not challenging the notice. Provisions, the law. So not our court was pleased to entertain it, and not was pleased to direct that I should submit a reply. The adjudication order will not be given effect to. So not. And then not the revenue, because there are several such petitions all over the country. Revenue filed a transfer petition before the Honorable Supreme Court. Those matters stand transferred there. So that larger question will be decided there. Now, when this adjudication proceeding has started, so I made the request in January and February 2024 for this particular investigation reports, which is referred to in the show cause. But the authority, the Directorate General, they said that you take it up with the adjudicating authority. So I wrote a letter to the adjudicating authority on 15 February. So they sat over it. Then in November, end November, they fixed the hearing for the first time on 3rd December. So I sent a letter that I've already put in this request for these. So please give me that. And in any case, this is too short a notice. So they do not deal with my request. They fix another date of hearing, which was 23rd. So they are not dealing with this particular request of mine, and regarding the copies.
What is the period within which this adjudication has to be completed?
5th February 2025.
25th.
No, 5th February 2025.
Within 1 year. Limitation?
Limitation is actually the notice was issued on 28th of October 2023. 28th October. So the time will be calculated. It will be in February.
Effective
But
date.
if the court is pleased to stay, then that period will get excluded.
No,
it's not that.
no.
In any case, presently, since we are on the last day, I can get into the merits insofar as my claim is concerned. But in fact, there's a decision of the Honorable Bombay High Court on a similar situation, my parent company, and there the Bombay High Court was pleased to direct the investigation report to be disclosed after redacting the sensitive part. That was the decision which I had relied upon before the.
What was that decision? Why the
learned judge was pleased to observe that it's not binding on me, and it
has a persuasive
yes,
value.
Yes.
Distinguish the persuasive value.
39. Investigation report আমার
Delta
কোনো
population.
investigation report-ই দেয় না।
This is 32, 45, 50.
এটা কোন ডিপার্টমেন্ট?
ওই যে বম্বে হাইকোর্ট থেকে তো ওনারা রিলাই করছে।
ডিপার্টমেন্ট
এই DGST ওখানকার বম্বে
They have a
30
ওইটা বের কর।
ইন্টারনাল ইনভেস্টিগেশন রিপোর্ট আছে, এখানে দেখুন আমরা কিভাবে র্যাঙ্ক করেছি। Investigation report they include so-called motivates.
just note down. Give me a hard copy of the ground. Just give me one. So it is a withholding of the the sensitive information, which according to you never sought for.
No. In fact, the judgment that I relied upon that says that that has to be redacted, it is not to be given to me. So it is not my prayer at all that I should get something which is sensitive. But there's judgment of the Honorable Supreme Court in the case of Takano, which was considered by the Bombay High Court, and thereafter the particular direction was given. If my lords are
Sensitive information, why they will not disclose all this? They are adjudicating authority, they are adjudicating on the basis of the materials which would be there.
না, কি বলেন?
Why don't you give them all the information except the very, very incriminating
sensitive part, they don't know. I don't know.
sensitive information?
Lordship, let's know. We will not go on a theoretical basis. We will come to show cause notice. We will go one by line. I will show there is nothing relied by my department. Which-
Then on what basis?
And then I have given him a letter. Lordship, he has to somehow cross that time bound. He is trying and fighting to cross me over 5th of February.
No,
No, Lordship. Now, Lordship, what I am saying is I have given him a letter.
When is the next date fixed?
Next date I am not aware of because
Adjudicating also.
adjudicating authority can tell Lordship I am appearing for the intelligence part, Lordship. Now, Lordship, what I am saying,
We have seen that Takano judgment, and the learned judge was of the view that he is really seeking sensitive information.
No, Lordship,
That
kindly.
says that it cannot be justified. Now, suppose you have issued a show cause notice. If you have issued a show cause notice, they are supposed to give a reply, which they have replied,
15th February,
which they have replied. Now you wanted to adjudicate it.
Yes, Lordship.
That means if you have not disclosed any document,
I will be not allowed to be ruled upon. I am
against the- if you do not rely upon any document, no difficulty, adjudicate on the basis of whatever the so cause and the reply.
Lordship, I have given a list.
If you rely on a document,
I have given him a copy.
where is the copy?
Yes, Lordship, he has acknowledged. Kindly seek the show cause. Lordship, kindly come to my show cause once.
Sure,
Kindly come to page 95.
sure.
Yes.
So,
Each document I have given inspection. Yes.
They wanted that.
Lordship, kindly come to page 95. P1, show cause notice.
Without that,
Now, Lordship, kindly come to show cause notice,
Yes.
which starts from 95. Then I said that I have done. Now, kindly see para 3.
But if my learned friend will not allow me, kindly see page 95, the opening paragraph. Page 95, the opening paragraph.
No, Lordship was indicating.
No.
I have taken the lead. Please, no, you can
Of course, but once. Of course, then as I am called upon by my lord, so I am trying to. Lordship, kindly come to para 3. Lordship will find that RUD1, RUD2, RUD3
That is what we find.
relied upon documents.
The Panchanama
Lordship,
statements.
Huh.
529 দেখাবে।
Lordship, kindly see this all relied document I have annexed. Now, Lordship, kindly come to page.
These are the one is the Panchanama. And the second one is the statements which you recorded.
These are the document I am relying. Lordship, now come to Now, Lordship, again come to,
Then there is no other document.
yes, 20 documents, Lordship, 20 documents. Then page 100,
Then
page 100, Lordship will find RUD4.
a statement. I am faster than you. I know page 100. I know 3.6.
Yes.
I have read it.
102.
On the basis of the another notice under section 70,
Lordship.
you have recorded the statement. That statement was part of RUD4.
Whatever RUD, now kindly come to 529.
I am just trying to decipher any documentary evidence which you gathered. These are the statements which you record at the time of search and seizures. You record the statement. These are the statements which you have relied upon. This is what I really wanted to invite your attention. If you go by a statement, let them decide whether these statements are sacrosanct and can be relied. No difficulty.
Kindly now come to 529.
And copies of again statement on the basis of summons RUD 567 3.8.
So kindly come to page 529 once. 529. Document will find Lordship RUD 14.
529. Yes.
Yes, list the document.
Kindly,
Achinama,
Yes.
statement.
then
Certificate is
Yes.
given.
signed document,
Signed copy of the statement.
then screenshot, 12,
Statement.
admission
relevant
certificate.
provisions Showing the explanatory note, classification. Then the printout of the web portal.
Lordship.
Then have you given a printout of that?
Yes, he has received it at the bottom, Lordship.
Non-relied upon documents. Next paragraph.
And then next page is not relied upon document.
Also received this.
He also seen that.
The original inspection has been given.
Now, ওই চিঠিটা বের করে যেখানে আমি বলেছি আর কোনো ডকুমেন্ট নেই।
541.
And then Lordship 541.
Yes.
530, non-relied document.
Yes.
That also he has taken inspection, Lordship. His lawyer has taken inspection.
Yes.
Now 541. Then I surrendered before him in the month of February 2024. I have no more document to give you. These are the documents I will be relying.
Right.
541, Lordship.
Yes.
Then Lordship, in show cause, whatever document I relied, I have given him. He has taken inspection. His lawyer has endorsed signature. Then Lordship, in the next, the document, not relied document we have in the file, but we are not relying. That also given. That is page 530.
That is a law that they have to be given those because they may rely on that.
Lordship. So we have also given them. And then Lordship 541, where I said that I have no other document to rely on. Ketan sir, now,
What more?
But kindly look at the
All
notice.
the documents that they rely upon, they have given you an inspection of those documents. And then you have given a reply. Now you know the scope of interference against a show cause is very limited.
I'm not on the notice at all.
Limited.
Lordship.
The court will not substitute its finding. Now, adjudicating authorities, you go there.
No, kindly have a look at the notice once more. Just the relevant portion. I have not trouble my lord with.
What is there? Vagueness, any all these things. You take a plea.
No, question is not if there's a violation of natural justice, it means the clock will have to be put back later. So I'm trying to avoid that situation where I get the fullest opportunity and the matter is decided once and for all. But kindly take page 95. 95.
Yes. Yes.
But intelligence was shared by the Directorate General of GST Intelligence Headquarters, New Delhi, and was further developed by the officers of the Directorate General of GST Intelligence that Messrs. Deltatech Gaming Limited, known as SONSO, are engaged in online, web-based, mobile-based supply of actionable claims, namely betting, which they were showing as online games like poker, rummy, fantasy games like content-based cricket, football, etc. have contravened the provisions of so-and-so. So they say intelligence was shared and developed. So now I'm going to kindly see what they say thereafter. At page 96. In fact, page 97. 3.1. Acting on the basis of intelligence. they issue the search authorization.
Yes.
Now, kindly see the page 100. 3.5.
Yes.
Accordingly, a team of officers of DGGI KZU visited the taxpayer's Gurugram office at so-and-so with authorization for inspection under section so-and-so for the urgent follow-up investigation. So they talk about intelligence, they talk about investigation. So investigation would have resulted in a report. They refer to it in the notice. If there was no reference to it at all, I would not have been before my lords. They refer to it. They issue a show cause notice, which is 10 times my turnover in the last 5 years, and I have to I have to be given everything which is being relied upon. They have referred to it in the notice note. That is good enough. Whether they call it a relied upon document or not, in my humble submission, because this show cause notice would not have come into existence without the report. The investigation report would have to be there, because this, in fact, in course of the inspection, it was said to my client, and we recorded it in a letter, that they are saying that yes, it is there in the soft form in their system. But then, when I pressed for that, they said, we will not give it, you take it up with the adjudicating authority. I wrote to the adjudicating authority in February, 15th February, I wrote.
That's page 541.
And there's a written document, and they did not respond to it. Then they fixed the hearing in late November.
They may not rely upon a report.
The question is they have referred.
They might have, but they do not want to rely upon the report. They have to go on the basis of whatever the materials which they have. If ultimately the adjudicating authority may not be in a position, and the moment they wanted to rely upon the report, you may raise an objection.
But the moment this is referred to in the notice,
that report content.
Kindly let me make submission.
They may have said many things, but they have not relied upon any of such documents. And then, if they want to rely at the time of an adjudication, maybe recording of the evidence, I do not know what is the procedure which is followed. So if they want to record a further evidence, if they want to put those, the papers in evidence to form a basis or form an opinion, then in that basis, if they want to rely, you can raise an objection. This is violative of the principle.
I have already requested for it. They are keeping silent on it.
Suppose if they do not, then what is the
Well, kindly have a look at the Bombay judgment.
একটা document আমার কাছে আছে, but আমি rely করব।
Well, kindly have a look at the Bombay judgment.
To my interest.
Well, kindly have a look at the Bombay decision.
Detrimental to my interest.
Well, the court in Bombay, the court was pleased to ask them to put it on affidavit, and then they came up with the fact that there is such a report. Well, kindly have a look at paragraph 10 at page 3. This was the prayer before the Bombay High Court. C is not relevant for us. A and B was pressed. Now, kindly see paragraph 29. At page 7. 29, 30, 31, 32.
আমাদের এটা থেকে ডিফারেন্স 29 থেকে পড়ুন।
What the report is.
Paragraph 37, my lord should have seen it, and 45. 37 and 45.
That particular information you have to give. So, do you know? Whether any challenge was made to the Supreme Court against this?
No, no, my lord, not my lord.
Why you did not cite this judgment before the?
No, I did. It is in the opening paragraph. It is noted. No,
it is not. This judgment is not there.
no, it is there. My lord. Kindly see the
page 3, internal page 3
no,
of the
no. See the judgment itself.
এখানেই আছে স্যার
Lordship, kindly see,
Takano, you referred.
and Bombay they have.
But page 2, my lord, kindly see that.
Yes, it is there.
Yes.
But there is no reference.
আছে স্যার
It is there. My lord. Page
No,
2
no,
at the
there is no discussion on this.
my lord, learned judge was pleased to observe that it is not binding on the court.
There is nothing
Yes, there's no discussion at all, my lord. And they refer to Takano.
there.
স্যার এইখানেই বলেছি স্যার একবার দেখবেন এইটা দেখবেন বোম্বে হাইকোর্ট বলছে
It
this is
cannot be a different
Page-
এইখানে বোম্বে হাইকোর্টের ওরা বলছে সুপ্রাটা বলে
Just take your seat. Tell me about this Bombay judgment.
Para 34.
Please distinguish it.
Yes, yes. Para 34. Para 34 is the first distinction we have to make, Lordship. Lordship, the adjudication.
Same thing you are saying that you have not relied upon that report. The same thing was argued that you are not relying on that report.
No, Lordship, Para 34, kindly come. There is a clear statement that on conclusion of investigation proceedings, the investigation report prepared by the investigation team and an acceptance of the same by the competent authority, the said investigation report culminate into a detailed show cause notice which is sent to noticing. So, Lordship, here we can start the matter in a two-way. One, we can go into investigation.
Come to your counterpart there in the Bombay High Court's argument at paragraph 12
Paragraph?
of the same judgment.
Yes. Mr. Kambata submitted that assuming the intelligent report contained any sensitive information affecting the commercial interest of the third party, the same could always be redacted and furnished to the petitioner. However, refusing to furnish the investigation report would amount to breach of principle of natural justice, thereby denying the petition.
That is their submission. Anyhow.
So, Lordship, kindly, what I'm saying is, they said that if the investigation report comprise of the show cause notice.
Please come to paragraph 16. Sorry. I
Lordship,
referred a wrong
Lordship.
paragraph. Paragraph 16 is
Mr. Desai, relying on the additional affidavit dated this, submitted that the investigation report is, in fact, the impugned show cause notice. Hence, the show cause notice itself contained the document containing the entire fact relates to the investigation. So, what he
similarly, read.
she submitted that there is no separate investigation report as such, and the show cause notice should itself be treated as an investigation report.
17.
Mr. Desai referred to the impugned show cause notice and submitted that the same contain all details. She submitted that all the relied upon document have already been furnished to the petitioner.
What you are saying.
No. She submitted that apart from this, even the non-relied document were also furnished to the petitioner. She submitted that the statement has made in the report that show cause notice would be decided on basis of the document fund.
What you are saying.
According to she submitted that there was no breach of whatsoever the principle of natural justice.
What you say. That apart from RUD, you are not going to rely any other documents. Whatever is there is disclosed in the show cause notice. Everything you want to say.
Lordship, here is a difference.
Relied document you have given an inspection.
No, there is a difference.
Now what
Lordship, that his show cause notice is, what he said is, the birthplace of the show cause notice is the investigation. Investigation I am not giving you. That was his case. And my case is,
The very first paragraph, page 95, says about intelligence was shared
yes,
by the Directorate General of the
yes,
Intelligence
yes,
and was further developed
yes,
the officers of the Directorate General
yes.
of Zonal Unit.
Lordship, let's come.
Then having they declared are engaged in such and such, which they were showing as such and such place, and therefore contravened the provision of such and such, such and such, such and such.
Lordship. So what is this information? Let's come. Lordship, let me explain the department's procedure. Lordship, one is we hold on someone, we started investigation. And one is we found that there can be a evasion. Then what we do is, maybe in that case, we engage our officers to understand whether actual thing is happening or not. When we found that actual thing is happening, then we reach to the place and try to catch them. So, Lordship, this investigation is not investigation into his personal thing. Suppose we have taken a cause that all gaming will be chasing all gaming companies. So, the information I received from my Delhi office to here is also containing the third party information.
So that is why
That's what I'm saying.
Bombay High Court says that you can give that report redacting so far as the sensitive information, because you are not supposed to disclose
Third party information to
from where that's intelligence source, because that would have a cascading effect
yes, yes.
or a lot of big
Lordship.
ramification in your functioning,
Lordship.
because you have
Many other things.
Of the informers, you do not want to disclose their identity.
Yes, even my officers.
You.
Now, yes. Now, Lordship, this is the difference. Now, when there will be a investigation by me,
Then Bombay High Court judgments rest. To us, everything was on the same line. You cannot segregate one sentence from here, cull out one sentence from there, and then say that there lies a difference.
no, Lordship, no.
How a single judge will say that it is not binding on me as a division-based judgment of the Bombay High Court?
Actually, distinguish.
Was there any contrary judgment of this High Court to this? Tell us.
Lordship, kindly, yes. Lordship, that is one.
The whole country, there will be a very anarchy that every High Court will think.
I'm completely with you. So far as the law point is concerned, I'm completely with you. No, Lordship, kindly.
It may have persuasive value on us, may not have a binding effect
Binding on me.
on us.
What is it? Now, Lordship, kindly see what I am trying to say.
So it will be there. On the basis of Bombay.
distinguish. আমাদের কোনো রিপোর্টই নেই।
Lordship, we have.
Give them whatever the report, except that intelligence part. Within 2 days to him. And fix a date, conclude. We will record that he will not ask any adjournment.
No, Lordship, kindly see.
And it has to be concluded.
No, Lordship, what is fallen from your Lordship, kindly see.
Adjudication.
Kindly see, Lordship. Kindly let us what my learned senior friend placed. I will try to place it once. The intelligence was shared by the Director General of GST Intelligence, headquartered this, and further developed by the officer of the Director General GST Intelligence, Kolkata unit. So, Lordship, this part cannot go to him. Let's read one by one.
ইনভেস্টিগেশন রিপোর্টই নেই। এইখানে যেমন ডকুমেন্টস কি চিজ
বলছি। Lordship, kindly see, let's read the show cause notice once more, Lordship.
এটা দেখান তো যে এখানে কি কি ডকুমেন্টস ছিল, ডকুমেন্টস রিলেটিং টু স্পেসিফিক ইন্টেলিজেন্স এন্ড ইনভেস্টিগেশন রিপোর্ট। আমাদের কোনো ইনভেস্টিগেশন রিপোর্টই নেই।
If your Lordship kindly see para 10 once of the judgment, kindly see para 10 of the judgment and then my page 97. Lordship, kindly see para 10 of the judgment. The specific document they relied upon, document in the show cause, specific intelligence developed by the respondent number 6 and investigation report prepared by the respondent.
আমাদের কোনো ইনভেস্টিগেশন
So we have no investigation report as such. Kindly see the language used, merely using investigation. Am I with lordships?
এটা ইনভেস্টিগেশন আমাদের কোনো রিপোর্টই নেই এটা সাবমিশন অলসো ইন রেকর্ডেড ইনভেস্টিগেশন রিপোর্ট Government Council for the submitted this is our investigation report so
এটা হলো বোমের সঙ্গে হয়ে যাচ্ছে, এটা বোমে বলছিল না ওটাই ওটা।
না আমাদের তো ইনভেস্টিগেশন রিপোর্ট ওরা রেফার করেছে এখানে আমাদের ইনভেস্টিগেশন রিপোর্টই নেই কিছু
May I please?
Exhaust your energy.
I have to reserve something for the evening. Christmas Eve. Lordship, kindly come to para 10 of this judgment. The para 10 of the judgment is says specific intelligence development.
If you go by the spirit of the judgment, then that will be beneficial to them.
True.
Because the court there invited you to give an affidavit. The affidavits were filed.
Here also, that is why the court has recorded that we have no other information report.
So then we will simply call you for an affidavit. You give an affidavit, disclose whatever you want to say, and thereafter we will decide. That will agree that we are avoiding. Now you wanted us to open the mind. We are opening the mind for that. If
But
you say that this judgment, then we will invite you to
No.
file. And till the final adjudication is made, we have to.
We are always in the hand of your lordship.
We have.
It's a huge issue, lordship, of the country. We are in the hand of your lordship.
For the interest of the revenue, we are avoiding this. Only thing is that when you have, why you hide it? Give it to them.
Lordship,
So that
we
no
from
further argument can
from their only document I can show it cannot be there. Let's read the language once. If your lordship reads the language once,
do you say that there was no report
yes, there is.
prepared by an intelligence? Please tell me. We will record that you have said that there is no such report.
Lordship, can you come to
We will say that something. which is not there.
para 2 of the judgment, impugned judgment. Kindly see.
Two of the judgment what? There was a report, the intelligence report.
Lordship, I will only beseech your lordship to read these 3 paragraphs once more in the show cause. Lordship, see, if your lordship finds, I will leave it to your lordship. Kindly allow me. Lordship applies lordship's mind.
Whether there is a report or there is written report or there is no written report. Tell us. Say yes or no. We want.
It is no with regard to him.
No
With regard to him. Now, lordship, kindly come to.
No difficulty. We are not interfering in the order. You say that there is no report. What the report will be.
The submission before the learned senior judge was different. Kindly see at page 2.
Let them we record. Let them
Now, lordship, kindly come.
record.
Yes.
Record.
Lordship, kindly come to page 96 and 97. Kindly, lordship, read with me whether can be a report or not. Lordship,
We are saying that you are saying there is no report. We are recording that there is no report.
lordship, specified to him there is no report as such. If your lordship wants me, I can take a instruction from my client. It's an intelligence matter, lordship. I have to take.
We will record
Our
your-
phone. Yes, lordship.
Record your
Under instruction, no, lordship. My
report.
একবার জিজ্ঞেস করুন ইনভেস্টিগেশন রিপোর্ট আছে কি হ্যাঁ জিজ্ঞেস করুন now lordship till that time lordship I will beseech your lordship to look into this paragraph kindly and then lordship whatever I am in hand of your lordship but lordship I need lordship to look into that 3 paragraphs once more and then whatever lordship will say I will go by that
And will not make much more submissions.
so I can stop right now.
Thank you. We will
If you-
go by your 3 paragraphs.
Lordship will look into it and after that if lordship thinks
3.1 we have read.
no I will read just 2 paragraphs lordship and I will pause in between reading and I will ask myself whether this can be shared with or not.
Please.
Yes. Intelligence was shared by the Director General of GST Intelligence Headquarters.
Where from you're reading?
Lordship, page 95. Show cause reading top, which my learned senior friend has shown.
You said 97, so I was at 97.
Yes, 95. I'm sorry, my lord. Yes. Intelligence was shared by the Director General of GST Intelligence Headquarters, New Delhi, and was further developed by the officer of the Director General of GST Intelligence Kolkata Unit, such and such, south of this app mobile base. So, Lordship, if I go by this paragraph only, this cannot be shared with him.
Who says, sir, are you please, I think either my incompetence not to expressly percolate what is passing in my mind, in our mind, or I will definitely not say the converse is true.
Probably that is true, but that Lordship.
I am saying so, sir. Only question again. It is not a case that the sensitive information should be disclosed to them. We are against that. We will never permit or direct you to share a sensitive information to them.
True.
We are absolutely firm. We are on the issue. The other information which are not sensitive in nature, will you not disclose them?
Then Lordship, kindly see his paragraph 48 and this. Kindly see what he asks for.
That's why I say
49. Kindly see his paragraph 48.
I have exhausted my energy.
Kindly see his paragraph 48.
I compel you to exhaust your energy.
Lordship, kindly come to paragraph 48 of his. Kindly come to para 48. Page 61, para 48. Page 61.
Yes.
Based on the show cause notice annexure there, the petitioner seeking inspection of the document sought illustrated but not limited to. Lordship, this I have satisfied them. I have given inspection. No, Lordship, I am coming.
Please. Which illustratively include but are not limited.
Not limited. Let's go by one. The document to show what intelligence was developed. Next, document to show basis of the said intelligence.
Different, anyhow.
Now, investigation report prepared its agent, officer, or any other concerned personnel.
They wanted intelligence report.
Lordship, kindly see
what they wanted. Intelligence report. Investigation
report.
Investigation report. Sorry.
No, investigation report.
They wanted.
Investigation prepared by DGA.
They wanted, I think, if I am not wrong, you wanted it.
Document relied upon this. So, Lordship, 4, I have complied. 5, I have complied.
Now, question is there any investigation report or not? Yes.
Under instruction, there is no instruction.
That's all we are recording.
So, Lordship, so regard to 1 and 2, he is not entitled to.
The Bombay judgment also, so far as the interdepartmental communication, the Bombay High Court has also discarded that you are not entitled.
So, only 3 is the investigation report prepared by DGA.
Concerned with this. No difficulty.
We don't. Under instruction of my advocate on record, I am saying so.
That's all.
Kindly see what is observed in Learned Single Judgment, page 2.
Sorry, we will not.
Paragraph 3.
We'll say not sensitive.
The submission is that
we'll record. What is the difficulty?